Good morning, everyone. We'll begin shortly, just letting a couple people more join on. I know it was a snowy morning in Wisconsin, so probably just a little late. So we'll be starting the webinar shortly in 1 minute. Let's go ahead and get started. Good morning, everyone. My name is Margaret Fieldbinder, and I am the event coordinator at Diversified Insurance Solutions. I'd like to welcome you all this snowy morning to today's webinar on employment practices liability. Before I turn the mic over to today's speakers, I wanted to go over a few housekeeping items. First, everyone is currently muted in listen-only mode. This will help keep the webinar moving along and meet our designated time frame. If you have any questions throughout the program, feel free to type them in the questions box in the GoToWebinar screen. Feel free to ask questions throughout and we will answer them as best as we can. And we've also reserved time at the end of the presentation to answer your questions. If for some reason we aren't able to get to all of your questions, we will send a Q&A document to you within the next few days, along with a copy of the presentation and the webinar recording. Also, if you haven't already noticed, I've attached the copy of the presentation in the handout section of the GoToWebinar panel that you can download and follow along. With that, I'd like to turn the mic over to today's presenters, Adam Erickson and Eric Host from Hanover Insurance Group. So with that, please take it away.
Thanks, Margaret. Hello, everyone. My name is Eric Host, and I am the Management and Executive Risk Underwriter for Diversified Insurance here at the Hanover Group. I've roughly been with Hanover for a little over 6 years and had a very good working relationship with Margaret and the Diversified Insurance organization altogether. Adam?
Thanks, Eric. First and foremost, my house cleaning issues, I do sound worse than I feel. I'll do my best to keep my voice going during the next 45 minutes. Bear with me if it cuts in and out, and Eric will do a great job of stepping in my absence if need be. So your patience is greatly appreciated. My name's Adam Erickson. As you can tell on the screen, I'm the Central Region Manager for Hanover Management Liability. What that means is I oversee our central region for all things management liability, directors and officers, employment practices, fiduciary liability, kidnap ransom, fidelity and crime, and then everybody's favorite hot topic, cyber liability. Just a few things as we move through these slides. I am going to be very upfront. This presentation is designed to go in depth about employment practices liability. We will spend a little time in the weeds today going through the policy structure and where it comes from. But more importantly, for the group we're talking to today, we're going to spend some time talking about what this policy should be doing for your organization and have some examples of when it's been beneficial to the groups we work with. As you heard at the beginning, we welcome any questions during the process, so you don't have to wait until the end. But if you feel like reserving your questions to the end, that's more than fine too. But we encourage participation. On our first slide, outside of this one, let's go. There we go. This is your typical disclaimer. This is, if you want to read through that real quick, one thing that's important to note, I am the Central Region Manager. What I am not is an attorney, and I'm not an HR expert. My background is in underwriting employment practices liability and the risks inherent liabilities inherent to that. I cannot be a legal expert or legal resource in any capacity, nor am I an active full-time HR person. But I'll do my best to pretend like I'm an expert in all of those things. So of course, the biggest question to ask yourself is you're the person who's responsible for purchasing the insurance for your organization. Or if even more importantly, you're the person responsible for using the insurance at your organization, is why employment practices. And there's a lot of different moving parts here. And I'm going to touch on some of these slides here. You're going to find a number of themes we repeat throughout the day. That just means they're very important. I felt it was necessary to bring them up on multiple occasions. First and foremost, why employment practices? And it's because you have employees. It's because you have people you interact with on a day-to-day basis. It covers the company, full, part-time, leased, and seasonal employees. This will go as far as volunteers, interns, and a number of different people who will be working with your organization who are under your direction and under your control. It gives you coverage for discrimination, harassment, retaliation, constructive discharge, termination, failure to hire, and negligent supervision. One thing that's not on this that is so prevalent today is the Me Too movement, and a lot of this is going to touch on that. We even have an example that's very similar to that. And while we will not speak specifically to what's going on in the marketplace and that, what I can tell you is it is a heightened sense of urgency and a heightened sense of sensitivity in the marketplace to those types of situations. We've seen a renewed interest in employment practices recently as a result of that. It does cover things like emotional distress and invasion of privacy, depending on how the claims are brought. Something that's always important to remember is punitive damages are always available where they're insurable. Not all states allow us to cover what we call punitive damages or punies. So it's something to be aware of in the state that your respective state of operation is if that's actually allowed. Coverage for monetary and non-monetary relief, regulatory investigations, proceedings, EEOC matters, or the like. We always utilize the EEOC as an example, but there are plenty of regulatory bodies, investigative individuals who are out there looking for violations and looking for situations where they can bring a lawsuit. EEOC is the most common you hear referenced, but there are a number of them you'll see throughout this. And then it is full prior acts, which means this is something that covers you for anything that's happened since basically the dawn of time in your organization. Now, there are some specifics to that around retro dates that we will speak about a little bit later. But generally speaking, most of these products, our product and many of our similar domestic products, should be providing full prior acts, regardless of when you originally purchased this. The origins of EPL, this is one where I'll tell you that I'm not the expert in all things here, but these, for any of the HR individuals, especially on the line, should serve as a reminder of all the different things we're dealing with on the day-to-day. The EEOCs we're talking about earlier, age discrimination, which is becoming even more prevalent with the baby boomers, and the fact that anybody over 40 can technically qualify. Americans with Disabilities Act is pretty straightforward. The Family Medical Leave Act, the Fair Labor Standards Act is something you're going to hear multiple times throughout this presentation. FLSA, or more aptly described in our presentations or our products as wage and hour litigation. This has been an area of growth in our line of business for a number of years now, coming up on a decade. The reason for that is so much of what we do from a claims standpoint is a he said, she said gray area. One person accuses another person of some type of wrongful act, and then we have to sort out what actually happened. When it comes to violations of FLSA, it has a lot to do with your overtime, how you're classified as a employee, and whether or not you were compensated appropriately for that. It's created a very black and white atmosphere in what's otherwise a very gray area of play. It resulted in significant losses across the board in our industry, something that we are still trying to deal with to this day via sublimits, trying to understand the exposure a little bit better. And depending on where you are, and we'll touch on geography later, different states react to these regulations and have their own that makes certain states very, very difficult. The state we always pick on, right, wrong, or indifferent, is California. If you have locations, or if your clients have locations in California, if you are dealing with any type of operations where you even have an independent contractor in California, it heightens your risk significantly. Other states to be aware of: Illinois, your neighbors to the south, Very difficult place to do business. They spend a lot of time in litigation. It's definitely an area that you have to be very careful. Again, we'll touch on this a little bit more in the future. So here's the boring part. We're going to talk about some of the insurance stuff. The basic employment practices liability policies can be made up of two insuring agreements. The basic one, first party, claims brought or maintained by an employee. This includes part-time, leased, volunteers, seasonal, we touched on this a little bit earlier, interns, anybody you either compensate or have the right to direct what they're doing on the day-to-day basis. These are individuals that will be covered under this, and if they bring any suit for discrimination, harassment, failure to promote, wrongful termination, hostile work environment, bullying is another word that's popped up in the last 5 years or so that's worked our way into our definitions, because these are all things that trigger coverage. They trigger some type of wrongful acts because in conjunction with that, there's some kind of deprivation to career or opportunity. When you look at who you deal with on a day-to-day basis, even a small organization with 10 employees, at some point you're going to have turnover, at some point you're going to have people who apply for a job. These are all individuals that could potentially trigger coverage under this policy. There's an asterisk on this slide. It's next to independent contractors. These are a difficult class. Your 1099s. A lot of people utilize 1099s because it's a more affordable way to approach the marketplace. Maybe you don't have to provide them with the same level of benefits. Maybe they work for a number of different places and they're just a one-off. Most forms, including ours, will provide for coverage for independent contractors when you, as the employer, see fit. Meaning, hey, this person was working for us. We feel it's necessary to provide coverage for what they've done. So it's a caveat that you need to look at and make sure there's coverage on there if you're dealing with 1099s. There's a lot of discussion, especially in the transportation industry, around whether or not 1099s qualify as actual employees or not, if they're properly classified as independent contractors when you control what they do on a day-to-day basis. This is something that's working its way through the court systems as we speak in various levels. It's definitely something we're keeping a close eye on because we are curious, especially, like I said, in transportation. Think owner-operators for trucking companies. You know, are they actually 1099s or are they actually employees entitled to full benefits underneath your plans? The second insuring policy or clause, excuse me, is third party. So you have insuring clause A, which is first party, and insuring clause B, which is third party. In different policy structures, they'll pop up differently, maybe labeled differently, but ultimately they're the same two insuring clauses wherever you go. This is something that was not standard in the inception of EPLI that over the last decade or so has become standard on most forms outside of commercial enhancement. I'll touch on that later. The thing that is important to remember about here is now we're covering the people who are not your employees. Now we're covering litigation for natural persons other than employee, customers, patients, vendors, service providers, business invitees. In this case, a business invitee in this situation is you, the individuals who are listening. And it is me who is presenting or Diversified who is hosting this. If something was done here that was offensive or felt to be derogatory in any way, that's where this would be triggered. It's very similar circumstances, but a lot of this is driven by things that are said around the workplace. People don't think about this because a lot of times you have the same UPS person or postal person that comes in every day. They're part of the group. They don't think much of it, but things that are said around the workplace can be offensive and found to be in bad taste for other individuals. We see a large number of third-party claims. And a lot of it can go down to very specific to refusing to do work or business with a group of individuals. And it may be completely unrelated to this, but if they are a protected class or there's anything that it could be misread, this is a huge issue. This is why I encourage everybody to make sure they have both insuring clauses on these policies whenever possible. So the basic policy structure continued. Those are the two basic insuring clauses, and there's a number of things you have to be cognizant of across the board. And again, we're in the weeds on this. This is insurance people stuff, and this is something that's good for the buyers to know because then you can understand and ask, some good questions around the type of coverage you have, and make sure you're holding your brokers accountable for the type of policy they're putting in place. Things like a settlement provision. This is something that is widely discussed in the marketplace because it's a hot topic. It's not one that's triggered very often, but it's good to understand what it does. It's commonly referred to as a hammer clause. Traditionally, what this meant was in a past life, a majority of the forms were what we call 50-50 hammer, meaning if we have a lawsuit and we're defending it on your behalf, and we believe that lawsuit should be settled for $100,000, but our client disagrees with that. At that point, this settlement provision, the hammer clause, is going to be triggered, and we will pay $100,000. And anything above $100,000, because we did not settle, that gets paid out, 50% of that would be paid by our client. So meaning if we said we should settle at $100,000, but the total lawsuit ends up being $200,000, we would be on the hook for $150,000, and then $50,000 of that would come out of the pocket of our client. This is something that has been softened as the years have gone by to essentially an 80-20 in most forms, meaning 80% on the insurance carrier, 20% for the purchaser. In many cases, like in our form, we're removing it altogether. It's a strategic move. It's not one, like I said, that is triggered very often, but when it is, it's usually because we have a very rough piece of litigation. So it's a good one to be cognizant of. Another part of these policies is good to know or understand is that they are duty to defend. Many of them are duty to defend. And what does that mean for our client? It means that if you have any type of claim or something that triggers coverage under this form, it is Hanover or whoever your carrier's respective carrier would be, our duty and right to defend that claim, meaning 100% defense allocation. If there's a covered claim underneath there, we're going to defend it. We're going to bring on our panel counsel who are experts in the industry, and we're going to handle this claim from start to finish. There are situations that allow people to defend their own claims, and it gets into an allocation issue, which we'll touch here in a couple bullet points. But it does give you more control. However, it doesn't give you full 100% defense allocation. Actually, we'll skip ahead to that one real quick. When you have 100% defense allocation under one of these forms, what that means for you is by utilizing the duty to defend nature of our form and our experts, you will be provided with 100% defense. If you have 3 items claimed in a lawsuit saying these are 3 violations and only 2 of them are covered under our form, we will defend all 3 because we are 100% and they're all part of the same claim. Now, if you are handling this yourself and we have the right to allocate, we will make an expert estimate on what percentage of it is covered under our form. So in that example, where 2 of the 3 are covered, we may say that only 60% of that is relevant and we will pay you 60% of the defense costs. It is a way for us to keep an amount of control in the industry over the litigation process. But it's not ideal for every organization, especially if they don't have the in-house expertise to handle these claims up front. So that's why we many times push duty to defend is actually a better situation for most of our clients. Another area, and it's a hot topic these days, is your defense, within the limits or outside of the limits. In many cases, most of the domestic carriers write their policies within the limits, meaning if you purchase $1 million employment practices policy, you will be buying $1 million of any type of coverage, whether it's defense, settlement, so on and so forth. We do have the ability from time to time to write defense outside the limits, which would mean we'd write an additional defense limit to that $1 million. So in many cases, it might be an additional $1 million. So you would have $1 million limit with an additional $1 million defense outside. In some small nonprofit arenas, you might be afforded unlimited defense outside the limits, but there are triggers that limit that as well. It's impossible for people to go on defending forever. But something worth looking at and understanding, and it's a decision based on risk appetite, what you're comfortable with. There's no right or wrong answer there. It's what you and your broker sit down and decide is the best course of action for your client, or for their client and for you specifically. Coverage for subsidiaries. This is an area that is commonly mixed up in the marketplace and is one that's worth spending a few seconds to talk about today. Coverage for subsidiaries, and the confusing part is because something is commonly owned, you have a wealthy individual who owns multiple companies. Just because they're owned by the same person does not mean there are subsidiaries. These forms automatically cover subsidiaries. So what is a subsidiary? It's a majority or wholly owned entity of our insured organization. So ABC Corporation, that manufactures widgets, owns 100% of 123 organization. They're automatically covered under these forms. We are accounting for both organizations when we're considering coverage. Now, if ABC Corporation is owned by Joe and 123 is also owned by Joe, or let's say 123 is owned by Joe's daughter, Susan, those are not automatically covered entities. They're separate entities, legally speaking, and they will not be afforded coverage automatically. There's sometimes misconceptions in the marketplace about what qualifies as a subsidiary. I'm sure some of you are rolling your eyes right now saying, yes, we know this, but it can get somewhat convoluted when it comes to coverage issues. So it's important to understand and discuss with your broker all insured entities you're looking to cover, why you're looking to cover them, because the underwriters are going to want to know what are these organizations and why are we extending coverage to them if we're going to be adding them to this form if they're not qualifying as a subsidiary. So hopefully that clarifies some of the questions brokers ask around that. But anytime you can clarify that is greatly helpful to the underwriting process. Underwriting detail. This is one of those areas that so many people get frustrated because they say, well, the underwriter keeps coming back asking more and more questions, and we try to limit that as best we can just to not waste your time, because we know you're absolutely as busy, if not busier than we are in any given day, and you have to run a business. This is what we do. You don't do this for a living. This is a small part of your company. So we ask certain questions we need for both rating purposes, according to our filed rates in the marketplace that we are held accountable for, but also to accurately assess the exposure. And I'll touch on some of those here. HR controls, things like a handbook, HR professionals, preventative policies and procedures. If you ever have to ask what these are, take a look at one of our applications. We ask if you have anti-discrimination, anti-harassment policies in place. Are you ADA accessible? Do you have progressive discipline in place? That's what we're asking about here. And the importance of having a handbook in these situations, or having written procedures in lieu of a handbook that outline all of these. I always tell people, you can have the best policies in place. You have the best training in place, but it's never going to 100% protect you against somebody doing something that is your organization's held accountable for. And short of interviewing all of your clients, it's impossible to fully assess the exposure. What this does, it gives you, having these policies in place and having a handbook in place, it gives you a plausible defense. Meaning, hey, yes, this happened. This individual acted in a way that we do not approve of. And here's where we show that. This individual signed off on our handbook acknowledging we don't engage in harassment. We don't engage in discrimination. It gives us the ability to give you a defense when we have to go to court and show what the intent was. In absence of these, many courts just assume that, yes, you did nothing to prevent this and you're probably going to be held accountable for that. That's an area that having an HR expert in place, working with your broker for resources, and many of these forms provide additional resources through online resources and even hotlines with attorneys that give you a jumping off point to help you become more comprehensive, or at least point you in the right direction depending on the employment issue. Your geographic location, we touched on this a little bit earlier. There's certain states that are very, very difficult. They provide us with ongoing headaches due to how their design or how their litigation is held. There are less than favorable outcomes in many places, like surprisingly, Missouri, Illinois is not, as we discussed earlier. West Virginia is another. Pardon me. But the other part on there is international exposure, and whether or not your form is appropriate for those international risks. How people treat each other and handle each other in places like Canada, France, India are very different than how our laws, rules, and regulations are governed here. Not to mention, if you have a foreign parent situation, they may not look at our organizations and feel they need the same care that we understand that we need. So when we look for international exposures, it helps us to better understand exactly what we're looking at and make sure. And we do have, these policies are international. They will be triggered. They will trigger coverage in different countries and provide coverage there. Some countries, it's important to note, will want their own local paper. What I mean by that is a locally placed policy. Countries like Australia really demand that. They want to see that they have Australian underwriting company and they have Australian expertise there. They better understand the laws and regulations. That's what they prefer to have. That's another conversation to have with your broker if you have international operations. Do we need to find any locally placed paper to be compliant? Number of locations is pretty straightforward in the scheme of things. The more locations you have, the higher risk we consider an organization to be. It becomes less centralized or more decentralized from an HR standpoint. And the more locations you have, the more opportunity you have for less issues to pop up with lack of oversight and just day-to-day issues. So we'll be always asking that. Their previous loss history, frequency versus severity. We do look at if you've had previous claims or previous litigation. Sometimes we see organizations, large organizations especially, that have 3,000, 4,000, 5,000 employees. We expect to see claims because it's going to pop up. It's just a sheer numbers game. And a lot of them are just frequency. They're smaller, might settle underneath our retentions, but it's worth us noting to see if there's any trends there. Severity is another area that we do have catastrophic losses from time to time. We look close at that. Neither of these things preclude you from coverage from most underwriting companies, but they are going to ask additional information around the context and what's happening. And they'll make sure that they have a full understanding of those losses so they can properly underwrite around them and more than likely exclude anything related to them. There's an old proverb in insurance, never insure a burning building. Existing claims and existing litigation is our world in employment practices version of a burning building. We need to avoid it. And then the industry itself. Industries vary wildly even, and how they rate when it comes to exposure. If you look at industries that have high number of turnover or have a very outward facing presence, so we always tell people anything with beds and cash registers, definitely considered higher risk. We see, and we have the claims to support it, a higher frequency of losses in those situations. It's something we're careful with, and they are rated appropriately. Our retentions may reflect the higher risk, but it is something we take into consideration. A chain of restaurants with 25 locations is a significantly different risk than a manufacturer with 1 location and 30 employees. Sometimes when we were talking earlier about combining policies and combining subsidiaries, we have a wealthy individual that owns just that, a manufacturing organization that has invested in a number of restaurants and wants them all in the same place. They're not the same exposure, and we usually tell them you need to break those out. We'll handle them differently. They have different retentions, different restrictive language. They need to be handled separately. So if you're dealing with an organization, if your organization is one of those that has separate operations, sometimes looking at separate policies is the best risk management strategy. I will call attention to my own mistake here. It says EPLI can be obtained in 2 different ways. Typo on my part, it is 3 according to the bullet points here, so shame on me. What I am largely talking about right here is the package management liability program, where you can actually buy it as a modular policy. What that means is your employment practices is bought in conjunction with directors and officers, with crime coverage, with kidnap, ransom, or even cyber liability. Any 1, 2, 3, 4, 5, 6 coverages can be bought in conjunction with combined separate limits. It is one of the most common ways that these policies are purchased and is one of the most comprehensive policies. The monoline standalone is a part of that. Break it out and write the employment practices on its own. Certain industries only have certain markets that are willing to write them. Staffing is a good example of that. Minimal number of underwriting companies that are willing to take on staffing. That's why you would have a monoline placement. You write it by itself. And then the last piece is an endorsement to your current commercial insurance program or to your BOP, business owner's policy. And usually that's a throw-in. The limits are going to be lower and the coverage is not going to be as comprehensive. We would consider that as kind of an entry-level coverage policy. If you have, or you're growing, or you have concerns over the coverage there, it would be good to look at a standalone or a package deal that would expand coverage to what we're talking about today. Those vary wildly as well from company to company. So it's important to understand exactly what coverages you're being granted. Some exclusionary language, just to clarify what this is going to cover. Bodily injury and property damage. I always tell my new underwriters we exclude things for 2 reasons under these forms. One is something that's uninsurable. Think in terms of nuclear war and things like that. Two, things that are appropriately covered under a different type of policy. So we're not duplicating coverage. We're not overextending what we're trying to do here. Bodily injury and property damage is it's a P&C. It's a property casualty loss. It should be covered under your general liability and under your property coverage. It's just not what is supposed to be considered here. So we remove that out, with the exception of some carve-backs for things like emotional stress, which would be considered bodily injury. Wage and hour violations of FLSA, another one. Again, we will carve back coverage in limited amounts, usually $100,000 in the marketplace. But that's something that is specifically excluded from almost all of these forms because, as we stated earlier, it's very black and white, and it is something that caused significant losses in our industry to the point where it's nearly uninsurable for a long time. Prior and pending proceedings. Again, that's our burning building. If something's already aware of, it's just like, a lot of the conversation around pre-existing conditions and things like that. We can't be the go-to when something happens. You just go and buy insurance after the fact. And then employee benefits, because they'd be covered under different types of forms. Fiduciary liability is an area, employment benefits liability. There's a number of different ways that cover that type of exposure. These are some claims statistics I pulled from the EEOC. It's pretty straightforward, and I don't want to spend too much time on here because it's something that you should notice. In 2016, we're seeing an uptick again. And I think if you see the 2017 and into 2018, we're going to continue to see that. Two things have happened. One, the news. The news is always our best selling point. The Me Too movement, things like that, are pushing us up in an increase in number of claims. Two is we also have an aging workforce. We have baby boomers that are working longer than other generations. And we have a young, aggressive, and vocal group of people coming in on the other end. People like to refer to them as millennials. They're just young in career is what it is. It's something to be cognizant of, but it's at least interesting to look at the trends we've seen over the last few years and where we're going from here. Common types of claims, and I'm going to move a little bit quickly as we're starting to get closer to the end. I want to spend some time on our claims examples, but sexual harassment, discrimination, retaliation, demotion, termination, wrongful termination, most of these are brought in conjunction with what we would consider to be wrongful termination. Infliction of emotional distress, that's where we were talking about that carve-back earlier. Failure to hire, negligent hiring, misrepresentation, humiliation, invasion of privacy, defamation. These are still just the tip of the iceberg in what is potentially covered under one of these forms. These are just some of the more common claims that we've seen in recent years. We will see these all usually brought in conjunction with multiple claims. Failure to hire, or actually failure to promote in some type of defamation and or harassment or discrimination. Wrongful termination is often brought with discrimination. So it's not that any one of these things are going to be triggered. It's usually going to be more than one thing that is being brought as a claim. So the claims examples, the fun part of what we do on a day-to-day basis. I've pulled 3 claims we've had recently pop up. I'll speak a little bit to each of them. I try to give kind of a wide range. In this case, a nonprofit organization. While this wasn't the biggest payout, it's a good example of what we see frequently, and it kind of a death by 1,000 cuts. It's the little things like this that add up over time. This is a nonprofit with 10 locations and 500 employees. We had EEOC complaint alleging sexual harassment. After the investigation, no harassment was found. So these individuals didn't do anything wrong according to EEOC, but we still incurred legal expenses of $10,000. When many of these policies for nonprofits run anywhere from $500 to $1,500, it's a good trade-off for $10,000 to actually walk away with less of a loss. But this is something to also, if that goes in the other direction and it achieves a class action status, that $10,000 can become $2 million very, very quickly. So important to highlight that it's not just private companies, it is nonprofits are being targeted, and they're being targeted more than ever. We've seen our claims in that industry upticking significantly over the past few years, as nonprofits are now being held accountable just like private companies are, both in their HR procedures and by the individuals who work with them. There's no longer this buffer where they're doing good in the community and people treat them a little bit differently. They're treated like any other organization. The hotel chain. In hotel chains, again, cash registers and beds. tend to be high risk. Hospitality of any kind tends to be high risk because of the frequency of issues. In this case, this was a wage and hour claim, meaning there is some type of issue with the classification of the employees and how they were being compensated. In this case, the cleaning employees were being paid by room instead of hourly, meaning if they weren't cleaning, they weren't being compensated. This is a direct violation of wage and hour. Right now, the current demand is $500,000, and that's been brought down from the initial demand. We are limited, as we discussed earlier. We sublimit our wage and hour exposure to $100,000, and this is one of the reasons why. This is a potential $100,000 loss for us and a potential $500,000 loss for that client. I don't know many organizations or hotel chains that just keep $500,000 sitting around just for such occasion. This was an interesting one that popped up with a private company. It's actually a manufacturing organization. Is sexual harassment, discrimination, and retaliation. As you can see, the insured CEO was engaged in a sexual relationship with the claimant, who is an executive assistant for the client. After the relationship ended, the CEO became increasingly critical of the claimant, ultimately accused her of theft. Demand of $600,000, final settlement into being $150,000. A few things to note in this one, and I didn't put all the detail in here because I wanted to keep it to one slide. What it doesn't tell you is the CEO, upon terminating his relationship with that individual, started a different sexual relationship with that individual's sister, which further convoluted the situation, and it potentially puts us at risk of multiple claims. This is the type of thing that in the moment most people don't think about. It's a workplace relationship, and those happen, as we're all aware, all the time. You can't keep that from happening. It's human nature. But when it goes badly, it can go very badly. And in this situation, that's what happened here. Now, as one side is accusing the other of this and the other accusing the other side of that, it is what I said earlier, a he said, she said, and it's our job as the risk management experts and as the people involved in this process to try and decipher exactly what happened and make sure that it was handled appropriately. This type of situation, as much as it can seem humorous to some, it is not. And it is something that we find very commonly. These types of relationships lead to this type of litigation. In this case, $150,000 is probably a very good outcome for all parties involved. Common coverage enhancements. I want to touch on these very, very briefly. And some things you should be looking for. You're seeing multiple themes throughout this because they're important. The second one on this being FLSA, wage and hour. As you saw, there's a claims example there, and we mentioned it earlier. Very, very important. We started off at the beginning, there's two insuring clauses, third-party liability. It's important to remember third-party liability is not always automatically included when you're dealing with a BOP or commercial enhancement. You want to make sure there is coverage there. That's when the standalone products tend to be more comprehensive. And it is something that an underwriter might actually walk away from if they feel that the risk is too high. So it's something to ask your broker about and have that conversation. Sublimit for defense expenses for investigations brought by a government agency or alleged hiring, harboring, or illegal aliens. We call this investigative expenses. So something that's also in the market, in the hot topic right now is it's coverage for if you're being investigated for your hiring practices. Usually sublimited for various anywhere from $25,000 up to about $250,000, and depending on the industry that you work in, a potential issue and something you want to have on your policy. Sublimits for workplace violence. This is always on the front end of what everybody's thinking about right now. We're all concerned with the potential for workplace violence. It comes in many different ways, from a disgruntled spouse all the way to an actual terrorist type of attack. I won't go so far as to call it terrorist attack, but it's something that we see in the news frequently. It's something that is sublimited and put on here, usually expenses for things like counseling and security guards, additional coverage. It's an enhancement to these forms that is good to have as a almost no cost throw in. 24-hour access to employment attorneys via toll-free hotline. They can't act as a full legal representative for your organization, but they can be somebody there to bounce ideas and questions off of before a situation gets out of hand. Calling them saying, hey, we're getting ready to terminate a position. This has been going on. What are your thoughts? Claims management and expertise to handle disputes. The more reputable the organization you're dealing with is, the better their claims handling is going to be. But it's worth asking, hey, who is our panel counsel? what organizations do we have access to, what individuals and expertise do we have access to by buying this policy. We should be able, as a domestic carriers, to produce that panel and give you an idea of what firms we're dealing with to give you a little bit more peace of mind. We always throw cyber on here. It is trying to find its way in the marketplace. Cyber liability and the scheme of insurance products have been around for a couple hundreds of years, is something that is in its infancy, and you will see coverage enhancements to this. When a breach happens to your employees, somebody is able to gain access to your computer systems and is able to compromise your employees' information. Sometimes having the potential for coverage under this is a good thing. I always tell people it will never substitute for having a good, strong cyber liability policy in place in lieu of this. So we're at the end right now. I moved through quickly and I covered a lot of ground. So I would like to open this up and answer any questions that anybody has. You know, this is an opportunity for you to pick on the underwriter, which you don't always have a chance to. But I welcome any thoughts or questions that anybody may have at this time.
Thank you, Adam. We'll give you a couple minutes to type your questions into the chat box and answer them as we go. So please feel free to type your questions into the chat box. Also, if you are like me and have questions after the fact, please feel free to reach out to myself or your Diversified team, and we will happily converse with our partners at Hanover and get an answer to you.
And everyone, while you're thinking about any questions you might want to ask to Adam or myself, I want to summarize a couple of the key takeaways here today with regard to employment practice liability. I think the claims examples that Adam summarized are outstanding. You could see the dollar amounts that are attached to those are significant. One of the things that I always talk about to my diversified agent, as well as all the agents that I handle, is an employment practice liability claim can be completely frivolous. The insured's going to think that it's going to go nowhere. However, you always have to pay to defend them. Again, you can see the dollar amounts that came up in those claims examples can come up to 6 figures. And because the cost of employment practice liability is pretty insignificant compared to some of the other insurance products that you have to purchase, I think it's definitely worth the money to get those additional policies.
Doesn't appear that we have any questions at this time. So on behalf of Diversified Insurance Solutions and Hanover, we would like to thank you for joining us this morning. We certainly hope you found the information presented today of value to you and your organization. Just a reminder that I will be sending a copy of the recording, the PowerPoint presentation, and a Q&A document within the next few days. And as always, if you have any questions in the meantime, feel free to reach out to myself or Diversified or Hanover. Thank you for joining us this morning, and we hope you have a great rest of your day.
Thank you.